Senator from Franklin County, Senator Stanley.
Thank you, Mr. President. I now move that Senate Bill 777 pass. And speaking to that motion, sir.
The senator has the floor.
Thank you, Mr. President, members of the Senate. Senate Bill 777 is a bill that establishes a manner and method by which we can overturn wrongful convictions based upon what is now known to be bad science. And that is to overturn the conviction, that is to vacate the conviction, and the Commonwealth can reinstitute and prosecute that person if that petition is granted. It's a one-petition opportunity. It's a petition that goes to the Court of Appeals, and quite frankly, it enables us to get around and overcome what are very much limitations in the Commonwealth of Virginia. We have Rule 1:1 in our Supreme Court rules, which has every order of a conviction is a final order after 21 days. And then there are other two avenues of relief. One is actual innocence, which is limited in time and scope. And the second one, of course, is a habeas corpus. Federal and state habeas corpuses have different times. What we find, we have seen bad science occur here in the Commonwealth of Virginia and in the United States. By way of example, one example, hair analysis. In 2015, the FBI announced that its experts had overstated probabilities of matches in 95% of the cases it had reviewed. In Virginia, the Department of Forensic Science began reviewing convictions, and 5 defendants were notified of errors in 2016. You know, as an attorney, I can tell you that our legal system is not perfect, that innocent people are convicted. And what is our obligation is to make sure that we get it right, because when a government deprives someone of their liberty, it is the greatest thing and the most horrific thing, and it can be the most terrible power that a government possesses. And what we want to make sure is that when that occurs, that we have gotten that right. Texas has done this single petition for bad science, or what we call junk science, before. Only 13 petitions have come about. This has a sunset provision on it, so we can assess on how this is going. It has a one petition rule, which allows not only one petition, but the Court of Appeals to summarily dismiss that petition. It is limited in its scope, but quite frankly, it is needed so that we make sure that we get these convictions correct and do not rely on science, which may sound good at the time, but is later proven to be unreliable, which resulted in those convictions. Mr. President, we've had 13 convictions of people wrongfully for what has become junk science. And when we found out who the right perpetrator was in those instances, those perpetrators had gone on after the wrong person was convicted and committed 4 murders. So for those reasons alone, we need to make sure we get this right so that we have the right person serving the time. This is limited in what cases this would apply to, but it's another way where we have a tool in the toolbox to make sure that even in an imperfect system, Mr. President, we do everything we can to get it right. And I thank you, sir.
I thank the senator. For what purpose is the senior senator from Loudoun County, Senator Black, rise?
Thank you, Mr. President. Speaking against the measure.
The senator has the floor.
Ladies and gentlemen, there is a saying among defense counsel that time is our ally. The longer cases can be delayed, and the longer that goes on, the more evidence dissipates, the more the memories of witnesses become fogged by duration of time. Witnesses die. Witnesses move and cannot be contacted and so forth. Ladies and gentlemen, it is not uncommon that we have people who are declared absolutely innocent who have confessed in great detail to the crimes that they have committed, and yet we have questions raised about forensic evidence. I will tell you, there are few sciences that are more hard science than forensic science. I have been up to Northwestern University watching presentations by their coroner, and I'm going to tell you, they may be gory, but they are utterly fascinating to see how they are able to take fragments and so forth and arrive at very rational conclusions. Ladies and gentlemen, I am just really troubled when we go back, particularly when we have someone who has confessed. We had a very prominent case some years ago where we declared someone innocent. He actually came into the General Assembly and had standing applause and so forth. But the fact is that his background, not only had he confessed to the crime, but his background involved an unquestioned situation where he had burglarized and broken into the home of an elderly woman, smashed a wooden chair over her head, breaking the chair into bits, nearly killing her. And he stole a pistol from her and took it and then went and shot his brother with the pistol that he had stolen. And this is a man who received standing applause in the General Assembly. He had confessed. And I ran into an attorney from the Attorney General's office who told me, and I don't remember his name, so I can't repeat it to anyone, but he was very senior. And I said, what in the world are you doing with this case? And he said, we, within the department, we think he did it. But we think that he falsified portions of his confession. And there was DNA. There was actually DNA found in the rape victim's body. And it was not his. And that always raises the question, well, how many were involved in the rape? Was he the one who held her down and strangled her while the other one committed the act? These things happen. These things happen. And so I am very, very leery of taking a case that is very old where the victims and the relatives of the victims have no voice. Because they can't be reached, because they're in the grave or whatever. And we ignore the fact that there is a confession, a signed confession by the accused. And then people bring up questions. They say, well, we're not so sure about this technique or that technique. Well, you put that technique together with a signed confession, and they bolster one another. And so, ladies and gentlemen, I am very uneasy when we start revisiting these cases. I don't ever want to see anyone who is innocent punished for a crime, but at the same time, when we have typically, these cases involve the most vicious crimes, and the most vicious crimes are typically crimes committed against women. And I have no interest in seeing folks like that released, and so I would urge you to vote against the measure.
I thank the senator. For what purpose does the senator from Roanoke City, Senator Edwards, rise?
Mr. President, speaking in favor of the bill.
Senator has the floor.
I applaud the senator from Franklin for putting in this bill. We already have a writ of actual innocence based on DEA. All this does is extend it to other scientific evidence. We also know that science evolves. A good example of this is the science with regard to arson. They now have recognized there's a lot of junk science with regard to arson that people were convicted based on, and I've been involved in civil cases involving arson, and I can tell you it has been in a criminal case where I prosecuted with regard to arson, and there's no question that arson investigations and the science regarding arson has evolved, and that's just one example. So I would hope, Mr. President, it would be the pleasure of the body to support this. The public is enamored with these CSI TV shows. They keep going. There's so many of them. It's unbelievable. Every time I turn on the TV show, there's another CSI show on. And the public understands that, science is very important in the prosecution of cases. And as the science evolves, we ought to allow somebody who's been wrongfully convicted based on maybe junk science to be able to show that the science has evolved that proves they're actually innocent. And the worst thing we can do is convict people and hold them in prison when they're actually innocent. They ought to be given an opportunity to show their innocence, just like we have done with regard to DNA. So thank you, Mr. President.
Thank the senator. For what purpose does the senator from Rockingham, Senator Obenshain, rise?
Mr. President, I rise to speak briefly to the bill.
The senator has the floor.
Let me try this from a little bit of a different angle and just point out to you, nobody disagrees with the notion that we ought to be exhausting all avenues to make sure that people are not wrongfully convicted and that those who have been wrongfully convicted are freed as quickly as possible. And what I would point out is that this proposal, it does come from something that's been tried in Texas, and if everybody in here believes that we ought to try everything that they do in Texas, I got a couple of ideas, but I somehow doubt that that's the case. I would point out that this issue was sent to the Crime Commission and studied by the Crime Commission, and it yielded no recommendation from the Crime Commission at that time. It was studied in 2016. The Virginia Association of Commonwealth Attorneys indicated that they had significant concerns about this, not about the notion of exonerating people because of changed science, but because of the manner in which and the mechanism created in this bill. Some of the challenges include the difficulty for courts in determining whether scientific evidence has changed, whether there is going to be a battle of experts in each of these petitions filed. As was mentioned before, retrying old cases can be difficult, and I'm not sure that this navigates that effectively. And courts are going to have difficulty struggling with experts who change their opinions. I applaud the goal of this bill. I would respectfully submit that we don't need to advance this year. I think that it's a worthy notion, but it's just not ready. And I would hope that the body would not report or not vote for this bill.
I thank the senator. For what purpose does the senator from Eastern Fairfax, Senator Surovell, rise?
Speaking to the bill.
Senator has the floor.
Thank you, Mr. President. I don't want to trespass too much on everybody's Friday either, but just a couple really quick things. First of all, one of the reasons that perhaps Texas has a statute like this is that other states already have this kind of stuff on the books. They just have a much broader remedy to open up a conviction way after the fact. Virginia's 21-day rule is extremely harsh. It's extremely limiting. We've been hearing a lot of advocacy as to why we ought to look at that. And this, I think, is a very measured way to go to, and limited way to start to deal with that 21-day problem. In terms of the junk science, juries put a lot of weight on forensics, probably more weight than they should. And it's because all these crime shows on TV that people see all these experts and this CSI, this and that. And whenever you have somebody that gets up there and the judge says, okay, you're qualified as an expert, all of a sudden the jury gives them a lot of weight. And often we found that these experts, they're getting paid, and the theories that they use turn out to be complete junk. And the senator from Roanoke pointed out the arson issue. That's called burn pattern evidence. There was, it used to be that fire forensics experts thought that you could tell whether somebody poured gas on the ground based on burn patterns. That's been completely discredited. I think there's been about 50 exonerations around the country based on that. Another one is bite mark evidence. That's another one which has been completely thrown out. There's been people convicted based solely upon the fact some experts said that guy's teeth matches a bite pattern on somebody, and that's been thrown out. And the last thing I'll say is in terms of confessions, often police use this forensic evidence to get people to confess. So you tell somebody, hey, I got this expert that says you did this and here's why, and they use some junk science to do it. Oftentimes people, in the distress of a confession, we've found that confessions have become they're a lot less accurate than you think they are. We're going to hear about that hopefully later this session with this Norfolk 4 bill that's coming, where 4 different people four different people confessed to a rape, which they didn't do. But you put some evidence like that in front of everybody, they get scared and they confess, even though they didn't do it. So we need this bill. We need a remedy to get people out of jail. Their only remedy shouldn't be a writ of actual innocence or going to the governor for an absolute pardon. We need something like this, which makes it easier. So I'd hope the body would support the bill.
I thank the senator. Other than the patron, do any other senators wish to be heard on Senate Bill 777? Seeing none. Senator from Franklin County, Senator Stanley.
Thank you, Mr. President. In closing on Senate Bill 777, I just want to say just a couple things.
Senator has the floor.
Thank you, sir. This is a new post-conviction writ that vacates those convictions but subject them to new trials based on changed science only. So there you have to show that there's a new standard that discredits the scientific evidence that was used to convict, and that new science produces a different result. That is in the bill. When we talk about writs of actual innocence, remember you have to have the Attorney General's support to even be able to carry that writ of actual innocence, which is a limiting factor. Habeases are too short, 2-year statute of limitations, because this science can be found to be junk science years after. But the limitations there that I think the senator from Loudoun should know in the bill are that if someone pleads guilty, they're not eligible to make a single petition challenge under this evidence. There's no eligibility for guilty pleas, which would be close to the confession that he speaks of. It's only limited to certain major felonies. Only one writ per prisoner. And the Court of Appeals can dismiss summarily without taking any evidence or without even an answer from the Attorney General or require any answer or even proceed. It is the power of the court to determine whether to move forward. The standard through the amendments are that this must be proven by clear and convincing evidence that no conviction would be obtained under new science, or the discredited science has been proved that no conviction would be obtained. It has a delayed effective date until 2019, and it has a sunset provision in 2023, Mr. President. And actually, we have to have annual reports and filings notifying the General Assembly exactly how this is proceeding, which will allow us to look at it. The purpose here is to get wrongly convicted persons out of prison, because that's our obligation under this legal system. I mean, DNA evidence has opened our eyes to the reality that demonstrably innocent people were rotting away in prison wrongly convicted. We are paying millions of dollars, as we just had someone say the Norfolk 4. Ladies and gentlemen, this is too important not to do. And quite frankly, it's not going to have a run on our court system. So for those reasons, I move that Senate Bill 777 pass.
I thank the senator. The question is, shall Senate Bill 777 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 24, noes 15.
Ayes 24, noes 15. Senate Bill 777 passes.